Question 1. A California notary public is performing an acknowledgement for a document. Which of the following is required for the notary public to complete this act? A. The signer must sign the document in the notary public's presence. B. The notary public must administer an oath to the signer. C. The signer must personally appear before the notary public. D. The notary public must verify the signer's understanding of the document's contents. Answer: C. The signer must personally appear before the notary public. For an acknowledgement, the most crucial requirement is that the signer must personally appear before the notary public. This personal appearance allows the notary to positively identify the signer and confirm they are signing the document voluntarily. While the signer acknowledges their signature and typically signs before or at the time of the notarial act, the defining characteristic of an acknowledgement is the personal appearance for identification, not witnessing the signature itself or administering an oath. Always remember that personal appearance is the cornerstone of nearly every notarial act. Question 2. A California notary public may charge a maximum fee of how much for an acknowledgement, plus any travel fees? A. $10 per signature. B. $15 per signature. C. $20 per signature. D. $30 per signature. Answer: B. $15 per signature. In California, the maximum fee a notary public may charge for taking an acknowledgement is $15 per signature. It is important for notaries to adhere strictly to the fee schedule established by law, as overcharging can lead to disciplinary action. This fee structure ensures consistent and fair pricing for basic notarial services across the state. Always ensure your fee schedule is clearly communicated to clients before performing any service to avoid misunderstandings. Question 3. What is the minimum amount of a notary public's bond required in California? A. $10,000. B. $15,000. C. $25,000. D. $50,000. Answer: B. $15,000. A California notary public is required to obtain a $15,000 bond. This bond serves as a consumer protection mechanism, providing a limited fund from which a person suffering damages due to a notary's negligence or misconduct may recover. While it protects the public, it does not protect the notary, which is why errors and omissions, E&O, insurance is often recommended in addition to the mandatory bond. Think of the bond as a safety net for the public, ensuring accountability for notarial actions. Question 4. A California notary public's commission expires on July 1, 2026. What is the latest date the notary public can submit their application to renew their commission without a lapse in service? A. July 1, 2026. B. June 30, 2026. C. May 1, 2026. D. April 1, 2026. Answer: D. April 1, 2026. To avoid a lapse in their commission, a California notary public must submit their renewal application, including proof of completion of the 6-hour education course, at least 30 days before their commission expires. Given a July 1, 2026 expiration, the application must be submitted by April 1, 2026. This allows ample time for processing by the Secretary of State's office. Proactive planning is essential to ensure a continuous notary commission and uninterrupted service to the public. Question 5. Which of the following is an acceptable form of identification for a notarial act in California, provided it is current or issued within the last 5 years? A. An expired foreign passport. B. A state-issued identification card from any U.S. state. C. A California Department of Corrections and Rehabilitation identification card. D. A driver's license issued by a Canadian province. Answer: C. A California Department of Corrections and Rehabilitation identification card. In California, specific identification documents are acceptable, and a California Department of Corrections and Rehabilitation identification card is one of them. provided it is current or issued within the last 5 years. Other commonly accepted forms include a California driver's license or state ID card, a U.S. passport, or a U.S. military identification card. It is crucial to use only the prescribed forms of identification to ensure the positive identification of the signer, protecting against fraud. Always consult your notary handbook for the complete list of acceptable IDs. Question 6. A notary public's journal entry for an acknowledgement must include all of the following except A. The type of document. B. The fee charged. C. The signature of the person whose signature is being acknowledged. D. The signer's thumbprint. Answer: D. The signer's thumbprint. For an acknowledgement, a California notary public is not required to obtain the signer's thumbprint in the journal. Thumbprints are mandatory only for documents affecting real property or powers of attorney. All other details, such as the type of document, the fee charged, and the signature of the person whose signature is being acknowledged, are essential entries for all notarial acts. Accurately completing the journal ensures a reliable record of your notarial acts, serving as a vital tool for preventing fraud and protecting yourself. Question 7. A California notary public receives an unsigned document and the signer requests a jurat. What is the proper procedure for the notary public? A. The notary public should administer the oath, then allow the signer to sign in their presence. B. The notary public should proceed with the jurat as long as the signer appears to understand the document. C. The notary public must refuse the jurat until the document is signed. D. The notary public should advise the signer to get legal advice before signing. Answer: A. The notary public should administer the oath, then allow the signer to sign in their presence. For a jurat, the signer must sign the document in the notary public's presence, and the notary public must administer an oath or affirmation before or after the signing. The common practice is to administer the oath first, then instruct the signer to sign the document while the notary observes. This ensures the signer takes responsibility for the truthfulness of the document's contents under penalty of perjury. Remember, the core of a jurat is the oath and the signing in your presence. Question 8. A notary public may refuse to perform a notarial act if A. The signer is a family member. B. The notary public believes the transaction is unlawful. C. The notary public does not recognize the language of the document. D. The notary public is unsure of the signer's identity but is shown a driver's license. Answer: B. The notary public believes the transaction is unlawful. A California notary public has the right, and sometimes the duty, to refuse a notarial act if they have reasonable belief that the transaction is unlawful or improper. Notaries are not required to complete a notarization if they suspect fraud, duress, or a violation of law, even if identification is presented. While family members can have documents notarized, and a foreign language alone isn't a barrier, as long as the notary can communicate with the signer and verify the certificate language, suspicion of unlawfulness is a valid reason to refuse service. Trust your instincts and protect yourself and the public from potentially fraudulent acts. Question 9. What is the primary purpose of a notary public's official seal? A. To validate the identity of the signer. B. To authenticate the notary public's signature and commission. C. To certify the accuracy of the document's contents. D. To prove the document was filed with a government agency. Answer: B. To authenticate the notary public's signature and commission. The primary purpose of a notary public's official seal is to authenticate the notary's signature and commission. The seal contains specific identifying information about the notary, such as their name, commission number, county of principal place of business, and expiration date. It is a unique mark that, when impressed on a document, demonstrates that the notarial act was officially performed by a duly commissioned notary public. The seal provides a visual confirmation of the notary's authority. Question 10. A California notary public must maintain their official journal. A. For at least 3 years after the last entry. B. For as long as they are a commissioned notary. C. Until notified by the Secretary of State to dispose of it. D. For the duration of their commission plus 3 years. Answer: D. For the duration of their commission plus 3 years. A California notary public is required to maintain their official journal for the duration of their commission and for 3 years following its expiration, resignation, or removal from office. This extended retention period ensures that a comprehensive record of all notarial acts remains available for inspection, providing a valuable audit trail should questions arise years after a notarization. Proper journal maintenance and retention are critical components of a notary's duties. Question 11. A notary public in California is prohibited from performing which of the following actions? A. Notarizing a document for a family member. B. Completing a certificate of acknowledgement outside the presence of the signer. C. Charging a fee for a jurat. D. Notarizing a document in another county within California. Answer: B. Completing a certificate of acknowledgement outside the presence of the signer. A California notary public is strictly prohibited from completing a notarial certificate, such as an acknowledgement, unless the signer is physically present before them at the time of the notarial act. This requirement of personal appearance ensures proper identification and prevents fraudulent notarizations. While charging a fee for a jurat is permissible and notarizing for family members is allowed, as long as the notary is not a principal or directly benefiting, performing a notarial act remotely without personal appearance is a serious violation. Always ensure the signer is physically in your presence for every notarization. Question 12. When a notary public resigns their commission, their official journal and seal must be delivered to A. The county clerk where their oath and bond are filed. B. The Secretary of State's office. C. A local law enforcement agency. D. A trusted relative or friend for safekeeping. Answer: B. The Secretary of State's office. Upon resignation, expiration of commission, or death, the California notary public's official journal and seal must be delivered to the office of the Secretary of State. This ensures that the records of all notarial acts remain available to the public and the state for official review or inquiry. This strict requirement underscores the public trust placed in notaries and the importance of maintaining an unbroken chain of custody for official records. Question 13. A California notary public can advertise their services in a language other than English, provided they include which of the following disclaimers? A. I am not an attorney and cannot give legal advice about immigration or any other legal matter. B. I am an attorney in this country and can provide legal advice. C. I am a paralegal and can assist with legal forms. D. I am a translator and can translate your legal documents. Answer: A. I am not an attorney and cannot give legal advice about immigration or any other legal matter. If a California notary public advertises their services in a language other than English, they are legally required to include a specific disclaimer stating, I am not an attorney and cannot give legal advice about immigration or any other legal matter. This crucial requirement prevents the unauthorized practice of law, particularly among non-English speakers who might misunderstand the scope of a notary's duties. This disclaimer protects the public by clarifying the notary's limitations. Question 14. What type of notarial act would be appropriate for a document where the signer declares under penalty of perjury that the contents of the document are true? A. Acknowledgement. B. Jurat. C. Certified copy. D. Proof of execution by subscribing witness. Answer: B. Jurat. A jurat is the appropriate notarial act when the signer needs to swear or affirm to the truthfulness of the document's contents under penalty of perjury. With a jurat, the notary administers an oath or affirmation to the signer and witnesses their signature on the document. This contrasts with an acknowledgement, where the signer simply acknowledges their signature and voluntary execution. The key differentiator for a jurat is the oath/affirmation confirming the truth of the statements. Question 15. If a California notary public moves to a new county within California, what must they do? A. Reapply for a new commission in the new county. B. Notify the Secretary of State within 30 days of the address change. C. File a new oath and bond in the new county within 30 days. D. Both notify the Secretary of State and file a new oath/bond in the new county within 30 days. Answer: D. Both notify the Secretary of State and file a new oath/bond in the new county within 30 days. If a California notary public changes their business or residence address to a new county within the state, they must notify the Secretary of State in writing within 30 days. Additionally, they must file a new oath of office and bond in the new county, also within 30 days, to transfer their principal place of business. This dual requirement ensures that the notary's official records are up to date with both the state and the relevant county. Question 16. A notary public's commission may be suspended or revoked for A. Failing to deposit journal and seal with the county clerk upon resignation. B. Charging less than the maximum allowed fee for a notarial act. C. Notarizing a document for a coworker. D. Performing a notarial act outside of their regular business hours. Answer: A. Failing to deposit journal and seal with the county clerk upon resignation. A notary public's commission can be suspended or revoked for serious violations of notary law, including failing to deposit their journal and seal with the Secretary of State's office upon resignation, expiration, or removal from office. This failure disrupts the legal requirement for record retention and can impede investigations. Charging less than the maximum fee, notarizing for a coworker, or performing acts outside business hours are generally permissible activities, assuming other laws are followed. Question 17. Which of the following statements is true regarding a notary public's liability? A. A notary public's bond protects them from financial liability for errors. B. A notary public is personally liable for misconduct or negligence. C. A notary public is only liable if they intentionally commit fraud. D. A notary public cannot be held liable if they followed a signer's instructions. Answer: B. A notary public is personally liable for misconduct or negligence. A California notary public is personally liable for any damages or losses caused by their official misconduct or negligence. While the notary bond provides a limited financial recourse for victims, it does not protect the notary themselves, rather, it protects the public. Notaries must understand that their personal assets can be at risk if they fail to perform their duties correctly. Therefore, meticulous adherence to notary law is paramount to minimize personal liability. Question 18. What is the maximum fee a California notary public may charge for administering an oath or affirmation? A. $10. B. $15. C. $20. D. $30. Answer: B. $15. In California, the maximum fee a notary public may charge for administering an oath or affirmation is $15. This fee applies whether the oath is given as part of a jurat or as a standalone act, such as for a deposition. Adhering to the prescribed fee schedule is a fundamental responsibility of every notary public. Always confirm the current maximum fees to ensure compliance with state regulations. Question 19. If a notary public changes their name, they must A. Wait until their commission expires to reapply with the new name. B. Notify the Secretary of State and file a new oath and bond, all within 30 days. C. Simply update their notary seal with the new name. D. Only update their name with the county clerk. Answer: B. Notify the Secretary of State and file a new oath and bond, all within 30 days. When a California notary public legally changes their name, they are required to notify the Secretary of State of the name change and file a new oath of office and bond reflecting the new name, all within 30 days. This ensures that their official records and identity as a notary are consistently accurate. Failing to do so can lead to issues with their commission and the validity of their notarial acts. Question 20. A California notary public may certify a copy of which of the following documents? A. A birth certificate issued in California. B. A U.S. passport. C. A power of attorney. D. A driver's license. Answer: C. A power of attorney. In California, a notary public is specifically authorized to certify copies of only two types of documents, a power of attorney and a notary's own journal entry. This limitation is in place to prevent notaries from acting as record custodians for documents like vital records or government-issued IDs, which are typically certified by the issuing agency. For instance, if someone needs a certified copy of a birth certificate, they would obtain it from the county recorder's office, not a notary. Remember, a California notary's authority for certified copies is very narrow, focusing on documents directly related to legal powers or their official acts. Question 21. What is the maximum number of consecutive terms a person can serve as a California notary public? A. 2 terms. B. 3 terms. C. 4 terms. D. There is no limit to the number of terms. Answer: D. There is no limit to the number of terms. In California, there is no limit to the number of consecutive terms a person can serve as a notary public. As long as the applicant meets all current eligibility requirements, passes the exam, completes the education, and submits the necessary paperwork, they can renew their commission indefinitely. This allows experienced notaries to continue providing valuable services to the public without artificial restrictions on their service length. Question 22. When performing a jurat, the notary public must: A. Ensure the signer fully understands the document's legal implications. B. Administer an oath or affirmation to the signer. C. Verify the accuracy of the document's contents. D. Confirm the signer is legally competent to sign. Answer: B. Administer an oath or affirmation to the signer. For a jurat, the critical action the notary public must perform is administering an oath or affirmation to the signer. This act legally binds the signer to the truthfulness of the statements made in the document under penalty of perjury. While notaries confirm identity, they are not responsible for verifying the document's accuracy, confirming legal competence, or explaining legal implications. These are responsibilities of the signer or legal counsel. The oath is the heart of the jurat. Question 23. A California notary public's commission is valid for: A. 2 years. B. 3 years. C. 4 years. D. 5 years. Answer: C. 4 years. A California notary public's commission is valid for a term of 4 years. Upon expiration, a notary must go through the reapplication process, which includes completing a new education course, a shorter one for renewing notaries, passing the exam, and submitting all required forms and a new bond. This 4-year term helps ensure notaries remain current with laws and procedures. Question 24. Which of the following best describes the satisfactory evidence required for identifying a signer in California? A. Any government-issued photo ID. B. An identification document that is current or issued within the last 5 years. C. A reliable method that establishes the identity of the individual without reasonable doubt. D. Personal knowledge of the signer. Answer: C. A reliable method that establishes the identity of the individual without reasonable doubt. Satisfactory evidence refers to any reliable method that enables a California notary public to establish the identity of the individual without reasonable doubt. This includes prescribed identification documents that meet specific criteria, current or issued within the last 5 years, or the sworn testimony of 1 or 2 credible identifying witnesses who personally know the signer. The core concept is establishing identity with high certainty to prevent fraud. Remember, your primary duty is to prevent imposters from signing documents. Question 25. If a California notary public fails to notify the Secretary of State of an address change within the required timeframe, their commission may be a. Automatically renewed for a shorter period. b. Temporarily suspended until the change is reported. c. Revoked. d. Subject to an administrative fine. Answer: D. Subject to an administrative fine. If a California notary public fails to notify the Secretary of State of an address change within the required timeframe, 30 days, their commission may be subject to an administrative fine. While serious violations can lead to suspension or revocation, administrative oversights like late notifications typically result in fines first. It is crucial to maintain accurate and current contact information with the Secretary of State to avoid penalties.